misidentified her attacker. There are a couple of things about that that are significant. It was a cross-racial identification. Jennifer is white and her attacker was Black. And she was also subject to very suggestive lineup procedures. So the police, when they administered the lineup, did some things that were suggestive that are now known to lead to wrongful convictions. Jennifer and the person who she accidentally misidentified, Ronald Cotton, are an inspiring story. She's written a book, and they're now extremely close friends. They wrote a book together. They travel the country together giving talks, and it's so heartwarming, right? Go to family weddings together, that kind of thing. And she talks about the way that the system treats people who are involved in a wrongful conviction. So we know that obviously if someone is convicted of a crime that they didn't commit and spend time in prison, that's of course a terrible injustice. And you can see how the systemic flaws affect that person. But what's more hidden is that the system, the way that it currently is, also doesn't serve victims or their families well. If someone is wrongfully identified, right, they not only that not only leaves potentially a real perpetrator out to continue to commit more crimes, it also can cause pain in a family who has lost someone, pain and guilt on behalf of us, for a survivor who may have made a completely understandable error in identification. And so the system as it currently is doesn't serve us well. There are also stories of jurors who later find out that the evidence that they used to convict somebody who later turned out to not be guilty, live with guilt and pain from that error. The other thing that's important to talk about is that bad forensic science can turn people who are victims of crime wrongfully into alleged perpetrators, just piling on the horror and pain that they might have experienced. And so down here on starting on the lower left-hand side, I have a photo of a woman named Julie Harper, and she was wrongfully convicted of the murder of her beloved son when faulty blood spatter evidence was used in her case. So someone broke into her home and murdered her child. She caught that crime occurring, but was too late to save her son. And investigators looked at the blood that was at the scene and concluded wrongfully that her story couldn't have been true. She must have been lying and she must have killed her son. And later that was shown to be false when the real perpetrator, who was a serial killer of children, confessed while he was in prison. And she was later exonerated. But this is something it's so critical to think about that we often don't, is that she was a victim of a heinous, terrible crime. And after experiencing that, she was wrongfully convicted and sent to prison. There are also situations in which bad forensic science makes someone who is the victim of an accident into a wrongfully convicted person. So below here in the middle, I have a picture of Christine Bunch with her child. Her son passed away in a fire that was caused accidentally in her home when a space heater malfunctioned and started a fire. Faulty arson evidence was used in her case to say that it couldn't have been an accident and had to have been an intentionally set fire, and she was imprisoned after losing her child in a tragic accident. I particularly want to highlight the cases of these women because we often don't think about faulty forensic science as being a women's issue, but it actually is, because two out of every three exonerated women were convicted based on faulty forensic science, and 40% of exonerated women were accused of harming someone in their care. There are a lot of complicated reasons for that, but they do boil down to often to misconceptions about how women as caregivers should behave, and some anti-feminist views often. So it's something that's important to think about when we think about these kinds of cases. So as lawyers started to litigate these cases beginning in the late 80s and early 90s with the advent of DNA in courts, we started to realize there might be problems with forensic science. And in 2009, the National Academy of Sciences concluded that almost none of the forensic sciences met basic scientific standards. So only nuclear DNA analysis, which is one type of DNA testing, has been rigorously shown to consistently demonstrate a connection between an evidentiary sample and a specific individual or source. So the stuff that's found at the scene and the person who's been accused, only DNA has been shown to make that connection. So you'll notice they studied in this case all sorts of things. In this study, they looked at all sorts of things. They looked at fingerprints, they looked at bite marks, they looked at tool marks, they looked at all sorts of things, and they found that only nuclear DNA analysis had been shown to have this foundational validity, which I'll talk about in a second. Whoop. Okay. The other issue is that forensic crime laboratories remain adjuncts to law enforcement, right? That this is something that the NAS identified as being a real problem. So if the forensic analyst sees themselves as an employee of the police department, and we'll talk about kind of the way that bias can seep in, they tend to be on the side of the police rather than on the side of objective science. And I'll talk a little bit more about bias, but I just want to flag this for you that bias is not, and I'm sure that as a UU group, you've had other talks about bias and cognitive bias, but this is this is a cognitive error that all of our brains make, just because we're human beings, not because we're malicious, not because we're ignorant, just because we're human. And you have that risk of bias when you see yourself in a particular role. So if you're a forensic science analyst in a police department, you might see yourself as having that role of catching the criminals or helping the police. So some things to look out for that the National Academy of Science has said is a problem, right, are testing, starting with analysts being given the name of the suspect and being asked to link the suspect and the sample to the crime, not shielding analysts from other case information that can contaminate or bias their work. And often they don't have the kind of education that you would actually expect a scientist to have. Okay, so this report in 2009 identified all these problems, and they discussed the lack of objective evidence underlying most forensic science disciplines. They offered some suggestions for reform, and this resulted in some important progress, but critical areas have been very slow to reform. So like, for example, evidentiary rulings by courts, when lawyers come into court and they say, this type of forensic science evidence has been shown not to be very reliable and you shouldn't allow it in front of the jury, courts have often been quite reluctant to make that ruling. Plus, there have been significant setbacks in the past several years. Earlier in our conversation today, a couple of folks, I think it was Lorraine and Molly, talked about how or maybe it was before we started recording, but talked about how we have a new administration, right? And the prior administration was extremely hostile to forensic science reform. Jeff Sessions, in his career as a prosecutor, was long known to be very hostile to forensic science reform. And that, of course, manifested itself in the way that policies were administered in the prior administration. There's some reasons for hope now, and I will talk about that at the end. Then in 2016, President Obama's Council of Advisors on Science and Technology, the President's Council, the PCAST, set forth some practical solutions for a number of problems that continue to plague forensic science disciplines. And basically here I have just a couple of examples of rules, right? And how PCAST believes that the rules are not necessarily being followed in some of the forensic science that we use. So we talk in these cases about foundational validity, right? And for a forensic science method, foundational validity means that something is based on empirical studies, it's repeatable, reproducible, and accurate. It's at levels that have been measured and levels that are appropriate to the intended application. And the reason I explain that is because the PCAST found that none of these disciplines, except for nuclear DNA analysis, had met these standards for foundational validity, and yet they were still being used in court. Unfortunately, hostility to forensic science reform is a bipartisan issue. When PCAST came out in 2016, Attorney General Lynch said that she remained confident that when used properly, forensic science evidence helps juries identify the guilty and clear the innocent, which, guys, it makes my head explode because the report clearly said that it doesn't do that, right? The report is explaining why forensic science has not been helping juries identify the guilty and clear the innocent. And she also wrote that the department believed, the DOJ believed, that the current legal standards regarding the admissibility are based on sound science and sound legal reasoning. Again, the report had just said, no, it does not, right? The statement by the National District Attorneys Association was even more hostile to forensic science reform. They said that adopting the recommendations would have a devastating effect on the ability of law enforcement prosecutors and the defense bar to fully investigate their cases. I do not know how, it's hard for me not to become snarky. I do not know how better science is going to make it harder for people to do their jobs, but that's what they said. And the opinion of experts is really important because when we look at all those cases where bad science led to a wrongful conviction, more than half of them involved improper testimony, right? So that means that experts came to court and they testified beyond what the science could support, or they were just plain wrong, right? Or they exaggerated or overstated what the evidence showed. So we have dual problems. We have disciplines without foundational validity, right? So disciplines that we're uncertain about their accuracy, and we have situations in which we can be really confident that analysts testified beyond what the science could support. So why is change so hard, right? Well, it will surprise nobody who's looked at other civil rights and racial justice issues that bias is at the root of much of this problem, right? So one example that I love to give folks about how no one is immune to bias is the studies that have shown racial, gender, racial and gender bias in medical care. And that's because I think doctors are a great example of how someone who is highly educated, not ignorant about these issues, learns about issues in medical school involving bias, so certainly far from uneducated on these issues, still can't stop themselves from having bias. The National Academies Press also wrote this important report about how people's experiences of the healthcare system are heavily dependent on their race, gender, and socioeconomic class. People of different races and genders in particular receive different types of care. They have disparities in pain control, the procedures that they're offered, even how long they wait in the doctor's waiting room. And so I'd like to talk a little bit about, so hopefully this convinces you that bias is a human problem that we all have by virtue of having our human brains, and we can't educate it away. And I want to talk a little bit now about the types of bias that might come into play in these kinds of cases. So confirmation bias is a huge one, right? And that means the tendency to seek confirming rather than disconfirming evidence. These are, again, things that our brain does just because we're human beings with human brains. It's also the tendency to recall confirming evidence in a biased manner, to give it more weight when it supports the conclusion you've already made. It's also the tendency to interpret ambiguous evidence in a manner that confirms pre-existing beliefs. You can see how this happens in forensic science, right? Because if you have, for example, fingerprint evidence that's inconclusive, if you believe that the fingerprint of the suspect is, or if you believe the suspect is the person who left the fingerprint, you might be tempted to interpret their fingerprint standards and match them to the evidence in a way that confirms your pre-existing belief. So it won't surprise you to know that there have been studies done on confirmation bias in police investigations, and they've shown very clearly that police officers rate disconfirming or exonerating evidence as less reliable or less credible than guilt-confirming evidence that supports their initial hypothesis. Investigators also show marked confirmation bias when asked to form hypotheses of guilt early in the evaluation of evidence. So if you wait to make up your mind, you have less bias, but if you make up your mind early on in the investigation, you tend to have more confirmation bias. There's also this issue of role effects. This is another type of bias that comes into play in these kinds of cases. People's perceptions of their role can influence their decisions, right? And there's a bunch of studies done about that. So this is one of the risks of embedding forensic science within law enforcement. And then there's also this tendency to conform to the perceptions and belief and behavior of others, right? So if you have a team of folks who think in one way, you are more likely to try to be in step with your peers. This is an example from a case that I worked on. An expert testified for the defense and then received an email from a colleague that is frankly abusive, telling her that she was deluded at best and criminal at the worst, and then calling her stupid. And so you can imagine how this sort of thing, this sort of behavior would have a real chilling effect on a person who's willing to stand up for someone who's been wrongfully accused. And this is not an isolated incident. It's pretty straightforwardly nasty, but it's not an isolated incident. Experts who offer opinions for the defense tend to get a lot more backlash than experts who testify for the prosecution. So why is it important why is reform important? Well, we want to educate the public on the issues surrounding forensic science so they can be adequately informed if they're selected for jury duty, right? And we want to create a uniform expectations and policy so that forensic science can be stronger, and we can we have a framework to follow, which ultimately will lead to fewer wrongful convictions. But the guilt or innocence of the accused person is not the end-all focus. Rather, the use of only safe, reliable forensic science is the goal. And that's because we never know whether someone is guilty or not when they're accused of a crime. Anyone who's accused is entitled to due process, including reliable evidence and truthful testimony, no matter how guilty or innocent they may look at the outset of the case. So I want to just talk real quickly about, this is a case from Milwaukee. And Mr. Stinson served over 23 years for a rape and murder he did not commit. He was convicted based on expert bite mark testimony, which was the only physical evidence against him. Forensic odontologists claimed that the bite marks in his case were identical to his teeth and that there was no margin for error in their work. So now that you've heard about problems with foundational validity and problems with overstatement of what the science can support, hopefully you can see how this falls into those buckets, right? So it's incorrect for anyone, anywhere, no matter what, to say that they've never made an error and that there's no margin for error in their work. There are very few sweeping statements in this work, but saying I've never made a mistake and I could never make a mistake is one that is a statement that is almost always wrong, or that is always wrong. I can make a very firm statement there, right? And in his appeal, Mr. Stinson claimed ineffective assistance of counsel and that the bite mark testimony was not credible, but he was denied a new trial. In 2005, the Wisconsin Innocence Project accepted his case, and DNA testing of saliva and bloodstains ultimately excluded him. The re-examined bite mark evidence determined that the marks on the victim were not Stinson's, and in 2009, after undertaking their own investigation, prosecutors dropped the charges against him. So there are a couple of things to note about this. It's easy to look at these cases and say that justice was done in the end, which is true, right? And actually, Mr. Stinson sued the city and received a large settlement. But if you look at the amount of time it took to untangle the bad science that was present in this case, you can see why our organization is so committed to making sure the science is correct on the front end. Mr. Stinson lost 23 years of his life to prison. And even after it was shown that the bite marks were not his and the DNA belonged to somebody else, there was still a significant lag time between when he was released and when he was fully exonerated. Another issue that's come up recently and frequently is the issue of people who have been wrongfully convicted of shaken baby syndrome. Our organization represented 2 women who were freed this year after being wrongfully accused of abusing children in their care. Stephanie Spurgeon, seen here on the right, hugging her grandchildren, was a babysitter watching a little girl in her home who became very seriously ill and later died in the hospital. And she was accused of abusing that child despite the lack of any kind of evidence of trauma to her body. Amanda Broomfield, seen on the right here, shortly after her release, the day of her release from prison with her husband, was accused of murdering her goddaughter after the little girl suffered a terrible accident that resulted later in her death. And it's important to look at these kinds of cases through the lens that we just talked about of how women are often wrongfully accused and wrongfully convicted based on their roles as caregivers, and how unequivocal testimony by experts like this kind of medical finding in a child can only be caused by abuse and there's no other explanation. Those kinds of unequivocal statements can lead to wrongful conviction and tragedy. So I want to talk very briefly, because I'm mindful of time, I want to talk really briefly about another case that I think is important. And this is also a child abuse case, but it illustrates the principle that we talked about before about how these factors that lead to wrongful conviction are interrelated, like fish in the aquarium, not like rocks in a bucket, right? They feed off and use one another to come to these bad conclusions. So this is actually a documentary, Scenes of a Crime, that was made about a case in New York where a man named Adrian Thomas was accused of murdering his son. his little boy, who was medically fragile, stopped breathing at home, and they took him to the hospital. There was evidence at the hospital of a terrible systemic infection. The little boy had a pneumonia that had spread to his bloodstream. But there was a physician who claimed to have seen a skull fracture when they examined him initially. That is indisputably incorrect. This doctor later admitted he'd made a mistake, and the child died, and at autopsy it was indisputably shown that there was absolutely no fracture. But what happened is that this doctor told the sergeants investigating the case that Matthew was murdered. And so what the detectives did was they interrogated Adrian with that in mind, and they induced a false confession. They told him that he could save his son by confessing, which, as a parent, I'll tell you, like, okay, you'd confess, right? He expressed some suicidal ideation. They took him to the hospital because of that. And after an overnight stay, they picked him up and returned him to the police station. During this time, he was not allowed to be with his baby, who was in the intensive care unit. They also threatened to arrest his wife if he didn't confess. And they then fed him the confession. They encouraged him to do a reenactment of the alleged crime, feeding him details and correcting him when he got it wrong. Okay. Come on. Oh no. Awesome. My computer is frozen. Come on. There we go. Oops. This is a picture of him at his first trial with his public defenders, who were steadfastly committed to him until he was later exonerated, in this picture down below. But this is a great example of how a false confession changed the testimony of the experts who testified in this case, right? So Adrian was induced to give a false confession that was later really shown to be wrong because of the medical evidence in the case. But prosecutors took that confession and then also experts for the prosecution testified in line with the confession rather than in line with the objective medical evidence. When his case was overturned, what the New York Court of Appeals said, that's the highest court in New York, and what they said was that every scenario that he confessed to was suggested to him by his interrogators. They also found that there was not a single inculpatory fact in his confession that was not suggested to him. Basically, he was fed the entire confession. Another case where ultimately they got things right? But he spent 9 years in prison, and it destroyed his relationship with the rest of his family and children. I also want to talk about another kind of case, in which I'm calling injustice without wrongful conviction, right? So I'm talking about field drug testing. And this is another example where someone can really be a victim of terrible injustice without being wrongfully convicted. So in field drug testing cases, right, we have all of the cognitive bias and errors that lead to a disproportionate number of people of color being accused of crimes, because people of color are more likely to be stopped by the police, whether that's a traffic stop or being stopped walking down the street. And then the ensuing investigation, a pat down, a search of the car, can reveal items that police then refer for drug testing, or that they use a test kit that many of them carry in their cars. These test kits are notoriously unreliable. Studies show that between 1 in 3 positive results or 1 in 5 positive results, depending on the study, is a false positive. That's an enormous number, right? Fully 1/3. And I have here pictures of things that have gotten positive results on these field test kits. So deodorant, breath mints, chocolate chip cookies. There's a whole slew of them. The Washington Post had been for a while, a column called The Watch at the Washington Post had been keeping a running tally. To me, one of the most distressing ones is exposure to air can cause a false positive on these kinds of cases, on these kinds of tests. And so they're a real issue, because while people tend to not get convicted on the basis of field tests, because what happens is then that evidence gets taken to the crime laboratory. The laboratory does a more comprehensive, more reliable test, and then it's shown to then be chocolate chip cookies or deodorant or air. They don't result usually in a conviction, but they're really important because they can lead to arrests. They can lead to pretrial detention, and as you know, people who can't afford bond get held for long periods of time based on then the weight of this field test, which is notoriously unreliable. I don't probably have to tell you that if you have to spend some time in jail waiting for your trial, you're much more likely to do something like take a plea to probation in order to get out, because you don't want to lose your home, your car, your family, other kinds of things that might happen while you are being held in jail. And so if these tests are so bad, right, why do police departments continue to use them? Well, they can be used as a sign of productivity. So you can say, we did this many drug tests, we need federal grant money. And really importantly, they're a driving force in asset forfeiture. So in most jurisdictions, if you are using your car in the commission of a drug crime, your car can be impounded. If you're using other kinds of property, you have other kinds of property on you, your wallet, your money, in the course of a commission of a drug crime, that can be taken from you. And it's a whole administrative process that's very difficult to get your stuff back. So it's actually lucrative. So these bad forensic science, this bad test can be really lucrative. And so it makes it really difficult to change. So I want to conclude because I assume there will be questions, but looking forward, right? It's really exciting because the new administration has named Dr. Eric Lander as the head of science policy for the White House. And he is one of the authors of the 2016 PCAST report. So we're very hopeful, and we've had some preliminary conversations with their office. We're very hopeful that we can start to see some forensic science reform on the agenda. So we might be leaning towards some changes in this area. We're very hopeful. And we also at our organization do not just look back at faulty techniques that have been used in the past. We're also looking forward at new emerging techniques and trying to make sure that those new techniques get adopted in ways that are consistent with the fair administration of justice. So here I have a couple of pictures to illustrate the use of genetic genealogy. So the kind of genealogy tests you might buy at the drugstore and use to find like family members can be used to identify unknown crime victims. Can also be used to catch perpetrators who have evaded capture. So for example, here's a picture of the man who was known as the Golden State Killer. And on the bottom, they can also be used to exonerate the wrongfully convicted. At the bottom is Chris Tapp, someone who was wrongfully convicted of a violent crime, and genetic genealogy later identified the real perpetrator. So we work with stakeholders to make sure that these new techniques get adopted in a way that's consistent with privacy, with fairness, and with justice. So I want to just conclude with a call to action, how you can help. You can learn by going to talks like this one and educate others. We also have educational information on social media. We have a wonderful communications coordinator who puts lessons about forensic science in bite-sized chunks that we then put out on social media. We're at CIFS Justice on all social media. You can visit our website and you can give. So I'm happy to talk to folks about questions. I'm really happy for the opportunity to talk to you all today. Thank you so much.
Thank you very much, Kate. And we do have questions. The first question is from Dennis Merritt, and it's, what do you mean by nuclear DNA? What does nuclear mean in this case?
Yep. So the DNA from the nucleus of the cell, not the mitochondria, it's what we normally think of when we think of DNA. It's the DNA in your cells. But what they're talking about in the report is single source or simple mixture DNA. So it's clear from there's a lot of DNA present. There are a lot of cells to get DNA out of, and those kinds of, that's like the traditional kind of testing that you think of when you think of DNA testing. I can explain more if you want me to, but basically nuclear DNA analysis is the like traditional DNA testing that we think of.
Okay, thanks, Kate. Kate, can you see chat?
Oh, yeah.
There's quite a long question there, and my screen has just shrunk.
Okay.
To about 1/3.
Oh, yeah. Oh, that's interesting. Molly, do you want me to read this?
Yeah, that'd be great.
Yeah, it's a really interesting question. Writes, I found your incredulity at A.G. Lynch's response interesting. Can you address the confirmation bias and conformity effects present in our understandings based on the effects of today's journalism that has become polarized depending on the outlet? This link to slouching toward post-journalism from the City Journal discusses this change toward advocacy rather than reporting. Its assumption that the audience cannot assess evidence on their own, but must be led to a conclusion, and its polarization and increased subscription rate effects. So I'm not familiar with this article, but what I'm meant to express with those statements from prosecutors, Attorney General Lynch and the National District Attorneys Association, is that in the work that we do in forensic science reform and in criminal legal reform more broadly, there tends to be less of a, Democrat versus Republican, conservative versus liberal gulf. It tends to be more of a, prosecutor versus defense leaning gulf. And so even, someone appointed by a Democrat appointed by a Democratic president is susceptible to these role effects of being in a prosecutor's office. I hope that I'm answering this question. I'm not familiar enough with the journalism question to address it, I don't think.
Okay, we have another question. What is your estimate of the overall percent of wrongful convictions?
That's a great question. So the short answer is we don't know. Estimates range from 1% to 4% of really serious crimes. So the National Academies of Science did a study that estimated that 4% of all people on death row were actually innocent. People who study this, though, think that the percentage might actually go way up when we look at crimes like misdemeanors and lower level felonies, because if, for example, the potential sentence is small, you might be more likely to plead guilty. So if you're being held, I think I talked a little bit about this before, but like if you're being held in jail on a possession charge, right, for possessing some small amount of drugs, and you can't afford the bail, and you've been sitting in jail for several months, and someone comes to you and says, if you just plead guilty, you can get out and get probation. People tend to want to do that. So there is this idea in the criminal legal reform community that perhaps it's much higher than that in lower level, than that 1% to 4% in lower level crimes.
Thank you, Kate. Another question, will adoption of stricter standards result in more challenges to previous convictions? Is that the motivating reason that prosecutors are opposed?
That's a great question. I think that's probably a motivating reason. I think that also prosecutors are afraid of losing a tool that does also result in convictions that are not wrongful, right? And I think there's a lot of fear there, people saying, well, we've gotten justice for, like, let's say the victim of a violent crime using this type of evidence, and so why we can't lose that tool. I don't, the people who are prosecuting these kinds of crimes are not bad. I mean, they're serious people with a sincere desire to do justice. It's just that we cannot stop ourselves from having, again, these biases, these things that are not our fault, that our brains just do.
And Kate, another question. You mentioned genealogical tests as a new type of effective forensic evidence. I had thought that many of the genealogic tests are also not reliable. Is that not the case?
Yeah, so I didn't mean to give the impression that I thought that these were universally reliable. They're not, and that's one of the things that we're trying to make sure that testing that is unreliable is not brought into court. Testing that's unreliable is not brought into court as reliable. It's just that in a few situations, it has been applied in a way that makes us feel pretty confident that they've gotten to the right result. So, for example, in Chris Tapp's case, there were a lot of reasons to be very skeptical of his conviction, including a false confession. And when so genetic genealogy was used to lead investigators to a new perpetrator who was then tested and found to have DNA at the crime scene, right? So just like anything else, all of these forensic techniques the problems come in when they're used in isolation or when they're used in conjunction with other evidence that might be unreliable, like confession evidence or informant evidence. When you use them and they're backed up in other ways reliably with other kinds of evidence, then sometimes you can get to a good result. So yes, there are problems with the tests that are available right now. And that's one of the reasons why we can't rely on any one thing. And we have to take these other safeguards to make sure that we're not falling into the traps of any of the other causes of wrongful conviction, like false confession, like, informants, like wrongful, like eyewitness misidentification.
Thank you, Kate. That makes a lot of sense. This is another question. This one's from Lorraine. Is it difficult to build general public concern about wrongful conviction based on science? We have all been urged to depend on science in relation to climate change or voting outcomes or COVID.
Absolutely. I think what's important to remember about the kind of science that's being challenged here is it's not science. It's it bears very little resemblance to the kind of science that we trust when we look at something like COVID testing and treatment or climate change, right? The problem is that we're relying on something that isn't very scientific and calling it science. And so, yeah, I think if we apply real scientific principles to these issues, we might be able to make some progress and have more justice in the world. But right now, relying on these unreliable disciplines is causing all sorts of problems. But yeah, I mean, I think you're right. I think there is a little bit of a visceral, like, don't attack science kind of feeling about it. And I think that it does end up being a problem. It's why it's really important to dig a little deeper and say, well, wait a minute, actually, right? Some of these things just they're not science. They're not reliable.
And I love the way the positive orientation of your group's title addresses that. It's the Center for the Integrity in the Forensic Sciences. Okay, we've got another one. Experts are often paid well and get more gigs when they are convincing, that is, sure of their opinions. Why not have expert opinions written only and reviewed by impartial parties?
Yeah, so that's really interesting. That's something that Seventh Circuit, Federal Seventh Circuit Judge Posner used to advocate. Our courts have been reluctant to adopt that kind of system. That is a system that's present in other countries. Some other legal systems use experts just for the court. And it can run into its own problems, but it's an intriguing idea that's definitely worth exploring. And yeah, I mean, I think that's it, right? I think that that having someone who's really convinced of their opinion can be indeed more convincing. And I think that's also why it's really important to make sure that the science is strong, that it's well supported.
Thank you, Kate. This is from Anne. Will you share this video of your remarks with AG offices?
I don't know. Is that something that you guys do? Yeah, I mean, this is not anything that's a secret. I do trainings for prosecutors' offices, not for the Department of Justice at the federal level at this point, but our organization has done trainings for prosecutors, and including like conviction integrity units where prosecutors review old cases to see if they can find wrongful convictions. And I think it's really important that we work together on these issues. Just like I said at the beginning of the presentation, everyone is harmed by bad forensic science. It's a mistake to think that looking deeply into forensic science error will result in less justice. I think the evidence shows that it can only result in more justice. No one is helped when the wrong perpetrator or someone who did not commit a crime is imprisoned. It doesn't help anyone. It doesn't help the victim of the crime. It doesn't help. It certainly doesn't help the imprisoned person, and it doesn't help our society. When we think about tearing someone out of their, when I think of somebody like my client Stephanie Spurgeon, who didn't commit a crime, who was convicted of a crime that didn't occur, her family, the family of the child who passed away was obviously harmed by that terrible tragedy. And it's a double tragedy because Stephanie was separated from her family for almost 10 years. She didn't get to hug her grandchildren. She didn't get to see her daughter get married. She, didn't get to help her parents with the problems that they were experiencing as they aged. And so, I just think that we need to, that doesn't help anyone. And having better systems, fairer systems, more justice in the world can only help both people who are, convicted of crimes or accused of crimes, and people who are the victims of them.
You've truly helped us see that, Kate. We have one more question. We have several more questions, actually. How are we doing on time? Are we okay?
Oh, I think Lorraine's on mute.
Lorraine, I think you're on mute, Lorraine.
Bruce, are you able to stay a little bit? It's up to Bruce because he's running the keyboard here.
Okay.
Is it okay if I go ahead?
It's okay. Okay.
Okay, thanks. Okay. This is a hot one. Care to comment on the O.J. Simpson case and the effect of good lawyers?
Sure. So I think that it's easy to look at a high profile case like that one and say that it was unfair because the defendant had lawyers who were too good. But I would encourage you to flip that script a little bit and think about how, our system could be improved by the prosecutors shoring up their case, making a better case, and everybody getting quality representation and a fair trial. I think it's really easy to say, that person got off on a technicality, which, is easy to do in these real high profile cases. But I would encourage you to think about how everyone deserves fair representation and how far, far more often than the situation we saw in that case, people who, either were wrongfully convicted or, didn't receive a fair trial or, didn't receive the advantages in life that they could have had are disadvantaged and damaged by the system.
Thank you, Kate. And then we seem to have one more question here. In the Groveland boys case with Thurgood Marshall, the deputy created false forensic evidence, a shoe imprint, after taking the shoes of one of the suspects, and the expert was discredited by the prosecution. Can you comment on this type of prosecutorial misconduct?
I would love to. We can have book list with teacher right now. Another great book about this kind of forensic error and fraud is The Cadaver King and the Country Dentist. Devil in the Grove, such a good book. The Cadaver King and the Country Dentist is another book that talks about this, and it talks about the rise of bite mark evidence and the fraud that happened in Mississippi surrounding bite mark evidence and some other forensic pathology issues. Yeah, I mean, I don't really think that fraud is the driving factor behind most forensic error, but it certainly exists. I mean, if you follow the news, there have been a series of high-profile scandals at the crime lab in Massachusetts or in Boston, and there have also been some really high-profile crime lab scandals in Houston that has resulted in Houston completely reimagining their forensic science analysis system. They actually have a great system now that is in many ways very reliable, but those scandals are what led to it. But given that, yes, there is fraud that occurs. In fact, the bite mark examiner who is talked about in the Cadaver King, there's a video of him, essentially like creating and destroying evidence in a case that got a lot of acclaim a few years ago. It definitely happens. I think that in general, the error that we see is not fraud. It's well-meaning folks making a mistake. But certainly, yeah, fraud is a problem, and that's why it's important, right, to have people really understand understand how the system works, advocate for change, put in the safeguards that are needed to stop fraud, right? Because if we are deferring all the time to forensic analysts without asking for them to, back up their work with real science, keep good records, all of that stuff, that it creates an environment where it's easier to fake things like they did in Devil in the Grove.
Makes sense. And knowing your mother-in-law is an addict about books too, I would add two to that. These are two young adult books that were on the New York Times best list this year. This is My America is about a young woman whose brother and father are wrongfully convicted. And it is dedicated to the Innocence Project, Kate, that you worked with. They are definitely the heroes here. And the other one, this one, Dear Justice, is again about a young man who is incarcerated on poor forensic science. So also adding these two books for the reading list. So is there anyone else who would like to ask a question with their hand up? Or I see someone mentioned Devil in the Grove as well as a good book along this line. Well, Kate, I can't thank you enough. I think you've shown us so much about how your work is bending the arc to justice. Thank you, Dennis. I can see applause there from Dennis.
Thank you all so much.
Thank you.
Thanks much.
Thank you. Thank you.
Thanks so much, everyone. Thanks for learning about this. It's important.
All right.
Thank you.
It's scary. Thank you.